the senior presiding judge for England and Wales, and I propose to say a few words about the introduction of broadcasting to the Court of Appeal in this jurisdiction. Broadcasting from any court in England and Wales was until October 2013 prohibited under the Criminal Justice Act 1925. The government announced in 2011, as part of its open justice agenda, that it wanted to allow broadcasting from the Court of Appeal to promote a greater understanding of the justice system. Broadcasting from the Court of Appeal began on 31st October 2013 and was the culmination of several years' work. During that time, I chaired a small group of judges, officials and broadcasters to formulate a legal and operational framework. This was not an easy process. There were competing interests requiring careful management. It was not a change to be entered into lightly, and our principal concern was that nothing should be done to risk or compromise the administration of justice. It is crucial for judges to retain control of the court and ensure that there are no adverse consequences brought about by the broadcast of proceedings. To that end, it is essential that judges have the power to stop or suspend filming where it is in the interests of justice to do so and to ensure fairness to the parties. The commitment to open justice has to be balanced against the need for safeguards for victims and witnesses. Accordingly, it was agreed that there could be no filming of witnesses, parties, members of the public, or the contents of documents used by those in court. Only judges and counsel may be filmed and broadcast. We have not yet finally resolved all the questions relating to the position of victims of crime. The legal framework ultimately agreed consists of 3 or 4 components. First, primary legislation in the form of the Crime and Courts Act 2013, passed in April 2013. Section 32 of the Act allowed the Lord Chancellor, with the concurrence of the Lord Chief Justice, to make an order setting aside the conditions under which prohibitions on filming and photography in court, dating back to a statute of 1925 and a statute of 1981, could be set aside. Secondly, the statutory instrument, the Court of Appeal Recording and Broadcasting Order 2013, which sets out the parameters, that is, the conditions under which broadcasting can take place. And thirdly, the contract between broadcasters and government, which contains, possibly viewed as a fourth element, a detailed working protocol for day-to-day guidance on operational matters. As I have indicated, the statutory instrument sets out the main conditions on broadcasting. If anything is broadcast outside this framework, it is likely to be a contempt of court, dealt with by a criminal prosecution if necessary. Key elements of the statutory instrument include: first, recording and broadcasting can only be carried out by authorised parties who have entered into a contract with the Lord Chancellor. Secondly, there is a limitation on what can be filmed. Only proceedings in criminal and civil appeals are of relevance. Family proceedings and matters in relation to fitness to plead are excluded. Thirdly, recording is limited to the submissions of counsel, exchanges between the court and legal representatives, and the judgment. Fourthly, there can be no live broadcast of conviction appeal cases. Nothing can be broadcast until the conclusion of such a case, and if a retrial is ordered, nothing can be broadcast without the express permission of the court. Fifthly, nothing can be broadcast in contravention of any reporting restriction. Importantly, broadcasters remain responsible for compliance with any applicable restriction. Sixthly, the use made of the footage must be fair and accurate and is limited to prevent misuse. Proceedings must not be broadcast for the purposes of satire, light entertainment, political aims, or advertisement. Turning to the contract, this was prepared by the Ministry of Justice with oversight from the senior judiciary and external advice from a specialist media lawyer. A key feature agreed with broadcasters was that copyright would be assigned to the Lord Chancellor on behalf of the Crown. This enables the court to take action in the event of any breach of broadcasting conditions, notably in relation to misuse. The protocol to which I referred is annexed to the contract. It is an operational document which has the same legal force as the contract. The main difference is that the protocol is a working document and can be amended by agreement as and when necessary. It is used by people in court on a daily basis and is aimed at helping make the process work smoothly. It covers matters such as listing, conditions on filming, disruption in court, time delay for live filming, reporting restrictions, and governance. Before broadcasting began in earnest, there were 3 test periods in different courts over several weeks. This allowed us to identify and consider areas of concern and allowed broadcasters to test equipment. It was a crucial part of the process to see how it would work in practice and reassure judges that it would not be intrusive or unduly distracting for them. Cameras are fixed in specific places in each court to ensure that only an agreed view of the court, judges and counsel is available. A court video journalist sits at the front of the court, in front of counsel's bench, facing the judges. Such journalists sit at a small mobile desk containing the technical kit. Both the video journalist and the kit are discreet and unobtrusive to avoid disruption to the court. Some cases may be broadcast live, subject to a 70-second time delay, to ensure that inadvertent references to restricted names or other sensitive matters are excluded. The broadcasters have their own ability to blank out expletives or words that may offend their own regulators, and this is achieved by a short mute of the relevant material. Live streaming, as already indicated, may not occur in conviction appeal cases because of the possibility that a retrial may be ordered at the end of the hearing. It is vital that nothing is done to prejudice a retrial, so broadcasting in such circumstances can only occur when and if the court allows it at a future date. Filming can take place in any civil or criminal appeal court on any given day of the week, provided that broadcasters have notified the relevant list office by a specific time on the preceding day. In practice, broadcasters get lengthy advance warning as to the hearing dates of cases they may wish to film, so they will often confirm their plans with the court much earlier than the day before the hearing. It is essential that judges, court staff and parties are notified that filming will take place in their court or in relation to their case, so that any key decisions or concerns can be addressed as soon as possible. Many judges were anxious about this change in dynamic, and we ran a series of awareness and training sessions in an attempt to alleviate their concern. The legal and operational structure was explained, and broadcasters attended the awareness sessions to demonstrate how the process would work and what footage would look like. It was helpful for judges to see how they appeared and sounded on camera, as well as having an opportunity to ask questions and raise concerns on particular aspects of the proposed system. This is an iterative process. Without tempting fate, I think I can say there is a strong judicial governance structure in place, which will aim at keeping developments under review and ensuring adherence to the agreed framework. The review group meets on a regular basis, and a second judicially chaired strategy group oversees this work and will meet every 6 months.